Good morning, colleagues. This is Suhail Al-Janabi from the ABS Initiative. Many of you know me. I'm the co-manager, and I do have the pleasure today to guide you through the second webinar of the webinar series of the ABS Initiative. I'll moderate this webinar 1.2. It's on how to get started within the series options to implement access and benefit sharing in Africa. So I hope you are all safe and in a good health in this very difficult time. And we hope that with this series of webinars, I'll say some words on that in a minute, we can keep the ABS community in Africa together and make further progress, even if we can't be together physically. There are, of course, some housekeeping rules to the webinar. So in the first place, and I see that you are following it, please keep your microphones muted and also turn off your cameras. It's not because we don't want to see you, it's rather because of the bandwidth and in the interest of a smooth communication and that the system will not collapse. So next, please. Next slide. Yeah, hope it works. Right. So for those who have not attended the first meeting, or for those who did, a little bit of a reminder. We are intending to record the webinar so that it will be also available for others that are not able to attend this physical or this virtual session here. It will be focused on the presentation, so the PowerPoint slides and the voice of the presenters. They will be made available for download. Don't be scared. In the discussions that will follow the different presentations, the voices of the participants will not be made publicly available, so those will be cut out. But in order to capture what has been discussed, we will provide an anonymized summary of the discussions between the participants and the organizers in the aftermath. And yes, please, in the chat function of Teams, please type your email address in the chat if you want to receive the summary. And you do see this icon, which looks like a speaking bubble from comics, you know. So if you just pushed on that, then you can type in your email address, and you can also raise your hand, so to speak, if you want to raise a question or if you wish to contribute with a comment. Next. So as I already said, please keep your microphones muted and your cameras off. There will be, after the different questions and answers sessions, or there will be these sessions after all after selected presentations. As you see, please type question in the chat function if you have a question, and then you will be put on the list for the discussion so that we'll also have an order. And then, of course, we want to hear you. So if the moderator, if I'm going to give you the floor, then unmute your microphone and ask your question. Please limit your question to one or to one comment, because that will allow colleagues also to engage in the discussion. Next. Right, so in order to avoid any further confusion, please do not push any of the other buttons. Yeah, so the chat button in order to put your name on the list, type a question, the mic button on off, and if a toolbar covers part of the presentation, click once on the presentation and do not move the cursor anymore. So that means if part of the screen is covered with a bar, just go with your mouse on the screen, and then this bar, the toolbar will disappear. Next. So that was a little bit on the housekeeping, and now rather on the background and also the context. It's sad for all of us that due to the COVID-19 crisis and the impacts we are facing, also the initiative, of course, needs to postpone and to shift the national and regional activities in Africa. We're not sure yet when we are able to conduct the first physical meetings, Pan-African workshops, trainings, and so on. So at the steering committee of the initiative, where some of you have also participated, it was decided that we should make use of that time now to tackle questions and issues that are relevant for ABS implementation and furthering the process in Africa. So 4 clusters of remote support so far have been identified. And we are now in the first one, which is how to implement the Nagoya Protocol in Africa, and with that also to map where we stand and how to foster it in terms of implementation of the legal frameworks, the regulations, and onwards. Another important issue identified is to create more knowledge on mutually agreed terms and benefit sharing. This will be another cluster that is going to be addressed. Following the logic of the convention, there will be a third thematic series on to what extent can or is ABS already contributing to conservation and sustainable use. This is quite important in the context of the discussions of the post-2020 framework. And the hot topic, the hot potato, if one so wishes, it is also to deal with the question of digital sequence information related to genetic resources, to develop more capacity and outreach on that, so that within the international negotiations, Africa is better suited and positioned to discuss about this pretty comprehensive and complicated issue. All right, next. So in the first session, we have now options to implement ABS. We had 2 weeks ago a first introduction and an overall view on options on how to implement ABS, where the African Union guidelines inter alia were presented and discussed. But today we are really focusing on practical issues. It is on, well, how to get started. And there a number of dear colleagues will provide inputs, namely today it's by Peter and by Pierre. And then 2 further webinars will follow, one on what kind of legal instruments are suitable for what kind of measures, and also implementation of strategies. And then, of course, questions of technical matter in a 4th seminar. Okay, so having said that, I believe it's now time to hand over to Peter, and who will let us know a little bit about how how it is to get started, and if one needs to get in touch with other actors back home, how could one tackle that? Peter, I think the floor is yours.
Thank you, Suhel. Good morning, everybody. Next slide, please, Lisa. So in order to do that, to give you just a very brief introduction in what we call multi-stakeholder processes, I would like to invite you to just imagine. I mean, many of you are focal points, so that's easy. You would have funds at your disposal to actually do the work you need to do. Your minister asks you to set up an ABS system, so you have a clear mandate to do so, and you even know some legal experts in your country that have some ABS expertise and who are actually willing to support you and to draft legal texts for you. So you just go ahead, you get started, the work is done, and finally the legal text is written, and you even get it validated within your ministry. And then for its entry into force, the text just needs to be signed by maybe some other ministers and or needs to be adopted by the parliament. Next slide. And this is where then some issues might come up. Just as a few examples, maybe the Minister of Forests now sees some difficulties how this proposed ABS process fits into maybe a procedure that does exist already concerning access to non-timber forest products in community forests. So maybe there's some open questions and the Minister of Forest doesn't really see how these two procedures could work hand in hand. Or maybe some researchers criticize that the proposed ABS permit, as it is laid out in the text that has been written, clashes maybe with an existing research permit. Or maybe a parliamentarian says that in his or her eyes, the rights of local communities are not sufficiently respected in the proposed process, and that she thus currently or in its current state will not vote for adopting the proposed text. So there might be some issues coming up if you just do it, in your own corner with your colleagues in your own ministry, in your own division maybe. And that's what brings us to the multi-stakeholder processes. So next slide, please. So, there we identified, or those were just some examples for some risks that would come along if you work on an ABS system without a multi-stakeholder process, so to say, while not taking into account all the different stakeholders that have a word to say. So if you do so, the ABS system maybe will not work for all. There's so many different individuals and entities who all need to find their place in the system. And if it does not work for all, that's quite a big risk. And you might overlook some details, which can only be told or highlighted when you really get into exchange with all these people. And actually those who were left out in such a process, just as in that example on the slide before, the parliamentarian, they might block the process down the road. So there's a risk that you will never get to validate and adopt the system proposed. So this missing ownership of involved stakeholders can definitely hinder implementation. And on the next slide, I would just very briefly highlight some basics for setting up a multi-stakeholder process to give you a very first idea. So we always say, one should start with a core team, just try to find some people who are interested maybe in your own ministry, maybe already in some key sectoral ministries or line ministries, but just, get a core team that is interested. And then one of the first things is always a stakeholder map that just helps you to really understand who plays a role in your country that might be of relevance for ABS issues. And based on that, you can then, or that helps you to identify actually the key actors for the elaboration of your regulatory framework, with whom you can start brainstorming or discussing things. And there's one major and overall advice that we like to give is stay dynamic. Things might change. You might create alliances one day that will not work some days later anymore, or you need to, stay dynamic so you can find new interested individuals or entities with whom you might be able to move a certain step forward. And then another very important point is that you should try to harvest experiences on processes from colleagues. You're not the first one who probably who's working on a regulatory framework for a given topic or subject, and it can be very useful to discuss experiences of colleagues who have gone through the same process, maybe on another topic, to really learn from their experiences. And then it's really important to decide actually on a suitable mechanism for decision making concerning your specific topic. That can be many different things. It can be an ABS committee, a task force. It can be maybe an existing intersectoral decision making mechanism that already exists, that can then be used as well for ABS. So those are just some very broad overall ideas, and some of you might have already participated in a specific multi-stakeholder training that the ABS initiative has been offering for quite a while, which is still evolving, of course. We would like to ask on the next slide, we will see that, because we won't have the time in this webinar to really get into the details of a multi-stakeholder process, but we would like to ask you this question, whether you would like to have a specific webinar on multi-stakeholder processes. And if there is interest, you can just use the chat function, just as Suhail described before, and type in yes. We can see your name, and it's for us to get an idea whether there is this interest, and if there's enough people interested, we might elaborate a concept for such a webinar, and then try to see where we can squeeze it in the upcoming weeks. And if you don't see a specific need for such a webinar that would go into details on how to set up multi-stakeholder processes, how to make sure to have everybody on board that needs to be on board, you can just relax and get ready for the next presentation, I guess. With that, I have already finished on multi-stakeholder process, and I think Suhail will hand over to the next presentation. Thank you.
Yes, Peter, thank you for this overview on the necessity to consider multi-stakeholder processes, and looking at the colleagues that are all in the web here, I do see that there's a lot of experience in that topic, but there are, of course, a couple of untackled issues in that regard. And I think also that this is quite important if it comes to a question that has been raised by a colleague after the last meeting on the role of indigenous peoples and local communities in the ABS process, that this is definitely also a good frame to discuss the roles, the responsibilities, not only of governmental organizations and let's say official stakeholder groups, but certainly also of IPLC. So I'm interested to see whether we will get enough quorum and yeses on the idea of the multi-stakeholder processes. All right. The first topic we want to really dive into is following up on the presentation discussions from last webinar, and it is then on the African Union guidelines for the harmonized implementation of the Nagoya Protocol. Next slide, please. And you recall that in the English webinar, Pierre gave an overview on how the AU guidelines were developed and what the process was, and also what, let's say, the core and the essence of the AU guidelines are. And today, it's Pierre who will elaborate a little bit on, well, how can we make practical use of it, of them, in relation to the development or adaptation of national ABS measures. And in that regard, I would, of course, also underline that this series of webinars is not only a product of the ABS initiative, but it is developed and executed in very close collaboration with the African Union Commission. And I'm also happy to see that Marlet from the African Union Commission is attending. So I hand over to you, Pierre, on the AU guidelines and the use of them.
Thank you, Sahil. Good morning, everyone. So can we have the next slide, please? Thank you. I think it is important just to remind ourselves that the AU guidelines consist of two separate parts, the strategic framework and the practical guidelines, which is a hands-on tool for African implementers. Next slide, please. So when we're thinking about, when we were developing the guidelines, it was clear that there are certain principles that African ABS stakeholders highly valued. And these, in the end, became the policy framework, which was officially adopted by the AU Assembly, the highest decision-making body of the African Union. And these guidelines clarify that prior informed consent and mutually agreed terms are needed for all access to African genetic resources and associated traditional knowledge, even if no national ABS measures are in place in a country yet. Right? And this is a very important point because the way that the Nagoya Protocol is structured and interpreted, for example, in the European Union's regulations, is that if you don't, as a country, explicitly require prior informed consent for access, by publicizing that on the ABS clearinghouse, the assumption is that your resources and your traditional knowledge are available for free access. Right? If you have not said that you require access, then everyone will just assume that they don't need your prior informed consent. And so a very important first point is, even if you don't have regulations yet, please put a notice on the ABS clearinghouse saying that as an African country, your country recognizes the framework that was adopted by the AU Assembly and that there is no free access possible in your country, and then they can contact you and wait for you to develop your measures. All right. So the framework sets a common African direction, and then the practical guidelines, which is a working document which responds to changes as they happen and was therefore not officially adopted, is there to guide the development of national ABS processes and to provide some interim tools in the annexes that you can use while you're developing your national measures. Next slide, please. Yeah, so this is just a little bit more detail about the practical guidelines and the annexes that they contain. This is step-by-step guidance. It's primarily aimed at focal points and other stakeholders involved in developing and implementing ABS systems at national and local level. Right? And because different countries have different legal systems, have different administrative infrastructure, have different division of responsibilities between line ministries, have different levels of recognition of, for example, the rights of IPLCs and so on. The guidelines are designed to leave you with a very large degree of national discretion and flexibility in how you actually put the system in place practically in your country. And then in the annexes, there's a model application form. There's an outline of a basic ABS agreement. There's a commentary on key elements to complete an ABS agreement. And then there's some guidance on the basic principles for community involvement in ABS. Now, I'm not going to repeat what Peter has already presented on the importance of the national multi-stakeholder process when you get stuck into this work. What I want to point out two things which are really important to bear in mind. One of them is that users of genetic resources, the people who will come and access the resources from your country, they need to comply with legislation in their jurisdictions. This is at least true for all users based in the European Union and for all users from Switzerland which have put in place compliance measures. Right, and so they will be seeking a permit and they will be seeking to conclude mutually agreed terms with you. And it's really important, if you want to provide access to your resources, if you want to get the benefits, if you want to have the technology transfer and the capacity building and eventually the monetary benefits that come from providing access, that you establish a legal procedure to provide such access in your country. And in doing that, it's very important to bear in mind as well that most countries, in fact, do already have legislation that to a certain extent controls research and development over their biological resources and in some cases traditional knowledge. So a very important first point as well, as Peter said, do a stakeholder stock take, but when you do that stakeholder stock take, also do a stock take of existing legal instruments and reflect on whether those instruments can be used in the meantime to put in place an interim ABS system. For example, many countries have a requirement that if you want to do research on wildlife or on indigenous biological resources or biodiversity, you need to get a research permit. Can you use that application for research permit to channel applications that are essentially ABS applications into a process where you then get to make a decision about granting access and you get an opportunity to negotiate mutually agreed terms? Next slide, please. All right, so I'm going to skip straight to the annexes because they provide the practical tools. If you have a multi-stakeholder process and you have reflected on on how you can handle through existing legislation or permit requirements and so on, the legal basis for applications. The most important thing that you would need after that is the prior informed part of prior informed consent. All right, and to get this, you really need the applicants to provide you with the details, because you cannot make a judgment about whether to provide access if you don't know all of this information that's in prior informed consent. Right. And because you cannot foresee what will be happening further down the line. All right. The application also provides a detailed record of what it was that you agreed to, because it was what you had discussed. And so it's important that this application is complete, as detailed as possible, and that it provides you with the information that you need to negotiate mutually agreed terms. And in fact, we recommend that you attach the application to the mutually agreed terms as an integral part of the contract, as a record of what it was that you had agreed with the user, what the user asked you to be allowed to do, and what you gave them permission to do. Next slide, please. So in this application form, there's a provision for different kinds of permits. One of them is for access to genetic resources, or access to and utilization. Another type, and you could of course apply for more than one type at the same time, is for access to and utilization of traditional knowledge. And they also can apply for an export permit, which many countries require because there's different provisions. There's obviously different considerations that you need to bear in mind if you are allowing users to take the resources out of your country and then utilize them in a different jurisdiction. Next slide, please. It's really, so you need to know who you're dealing with. Is it a legal person? Is it a natural person? There's all the usual sort of stuff that you would need to know. Its name, it's like legal identity, its contact information, the details of its partners, if it is working with partners, and also the individual people who are involved in the application and their qualifications and experience. Now, it's also really important in this case to have this information, because this allows you to make a judgment about whether this is a credible application, right? I mean, if you get an application from a large pharmaceutical multinational that wants to do research on a particular biological resource from your country, it's clearly a different situation than if you get an application from an individual who has no. You also need to make it. You need to be able to make a determination of the capacity of the applicant, right? So if you have a very capacitated applicant that has the ability, for example, to do technology transfer or do training, then it's a different situation from if you're dealing with an individual with no track record, no assets, no laboratory of his or her own, etc. Right. So it's important to also establish the capacity of your partners. Next slide, please. And then it's very important that you need to have a description of the project that is involved in the application. So what is the objective? What does it aim to do? In what context does it happen? What possible end products will it produce? What is the intended outputs of the research? The intended utilization. How will the resources and the knowledge be used? What exactly do the applicants intend to do with them? If they are partners, what are their role in the R&D process? Of course, you need a detailed list of exactly what it is that people are asking to access. You need to have details of the location where the genetic resources will be collected. And so just to say that you have to use a little bit of judgment in this, because in some cases, not all of these fields are necessarily applicable in all cases. Some of them would simply be filled in with not applicable. For example, if the resources are not being collected in a particular location, if they, for example, being provided by your national gene bank or by your national botanical garden, then of course you just say that was the provider there. Next slide, please. Also, in many, so the project also needs to have to have, when they're obtaining genetic resources or the associated traditional knowledge from an indigenous or local community, then you would want to see that there's an agreement with that community, right? And if there isn't, you might well, as a national focal point, be interested in ensuring that such an agreement is established before you take the process any further. All right. There's this issue of other permits. For example, in many cases, permits for research in protected areas will be handled by a different entity from the ABS authority. In some countries, the responsibility for wildlife and for plants would be split between different institutions, etc. And so when these other other permits are required, then you need to, of course, check that they are issued or that they have been applied for. And you need to have a process in place nationally to ensure that you don't issue one permit and then people use that one permit to bypass the need for other permits. You also need to consider that in this application, especially with large commercial partners, they would want this research to be confidential because they would not want their interest or their investment in a particular resource to be known by their competitors, because that opens up all sorts of problematic competitive practices. For example, ambush marketing by a competitor that's aware that a particular user is researching a particular resource. And so you want to conserve this confidentiality, but of course not to the extent where that no longer allows you to be informed about exactly is going to be done with your resources. And so you need to be clear that application is confidential, that if there's information in the application form that is confidential that the people would not want to put into that form, you need to then discuss a process for the disclosure of this confidential information. For example, by signing a non-disclosure agreement with the applicant. And then the applicants need to sign a declaration that the information that they've provided in the application form is true and correct, and that they will be held responsible for wrong or incorrect information. Next slide, please. You would also want some more information about the time and the duration of the project, because that obviously would also facilitate your interaction, and it would inform the reporting period, for example, the periodicity of reporting. If it's a short one-off access permit, then you could maybe do with one permit at the end of the research period. If it's a long and ongoing project with commercial development stages, you would need to have more frequent reports and maybe even establish a process for exchange of views and for further agreements down the line if certain milestones are met. You would want to know the potential benefits to your biodiversity. You would want to know the potential threats to your biodiversity. You would want to know the methods that will be used to minimize or avoid the negative or adverse impacts on biodiversity when it's being collected for access. You would want details about the knowledge of indigenous or local communities that is known to the applicant, and you would want to check that against what you know about the indigenous and local communities and their traditional knowledge around a particular resource. Because you can't expect that the applicant would necessarily know all of those things, especially when such knowledge is not available in the public domain, right? And so you need to establish what they have as background knowledge, and you need to establish that that is adequate. And you also need, in many cases, the written permission of the physical access provider, depending a little bit on your legal situation in your country about who owns genetic resources, who has the permission to provide physical access, and what conditions are attached to that. Do you additionally need, for example, a material transfer agreement between the access provider and the recipient? Next slide, please. So Annex 3 is a basic ABS agreement between the provider and the recipient on access to genetic resources or associated traditional knowledge for utilization. And when we were compiling the guidelines, there was a lot of argument about the extent to which we could go to provide this ABS agreement. Next slide, please. When you look at Annex 3 of the guidelines, you will see that it starts off with a series of disclaimers, right? So, there are a number of problems involved in this. One of them is that the ABS agreement is a contract, and in many countries, the law says only lawyers are allowed to formally work. Only lawyers that are registered in that country are allowed to work on contracts, all right? So it would actually be illegal in many countries to provide you with what you would be practicing law without a license if you were to provide a contract template. Right? And the point I can't stress enough is that you cannot use this as a template where you simply fill in the blanks and expect that you will have a working contract. You do need specialized legal advice on the actual contract, because you need to, on a case-by-case basis, meet the specific interests and goals of the parties involved in this particular agreement. So this is not a template. It's an outline of essential features that you must have in any ABS agreement, but without a prescription about exactly how those features should be in. Just to point out that there has been additional work done on this, and that there's now additional resources available outside of the AU guidelines, and that is actually coming into the webinar series. When we start delving deeper in how to negotiate MAT, there will also be more input on the additional tools that have been developed. Anyway, so moving on, next slide, please. In a typical contract, you would have a preamble, that kind of sets the background, sets the scene, right? And it's an important part of the contract, because if you do get to a dispute and you need to have a dispute resolution or even a court case, the information in this can be used for interpretation of the terms. All right, but this is just background information. It's not actually legally binding part of the agreement. Next slide, please. Then you need to put the definitions. What do things mean in the contract? You should, as far as possible, try to keep this consistent with the Nagoya Protocol definitions and to keep it consistent with any definitions that exist in your own legislation. Right? But you also need to make sure that there's an agreement that's acceptable to all parties about exactly what these terms mean. And then there's some examples here of what you can define, for example, utilization, the recipient, the provider, the party to the contract, and the third party to which the resources might be transferred later, etc. All right, next slide, please. And then you get into the nitty-gritty, into the meaty detail of the agreement, right? So there's the terms and conditions that are in the mutually agreed terms. Basically, the conditions, the conditions of access, the material transfer conditions, the benefit sharing arrangements, the purpose and the scope of the utilization after that access has occurred. Is third-party transfer allowed? Why? When is it allowed? What are the conditions attached to that? What happens when somebody takes a resource from you and now want to utilize it for a purpose that was not in the mutually agreed terms? Is there a process for changing the purpose of utilization, or does it involve a completely new application? You need to spell this out in the contract, right? You need to be clear about what is confidential and what is not. You need undertakings of confidentiality and non-disclosure where they are relevant. And then you specifically need to address the issue of intellectual property rights, right? You need to anticipate what intellectual property rights could come from this utilization, and you should decide in the mutually agreed terms, if such property rights are created, who owns them and how can they be exercised, who will be responsible for maintaining them, who will pay for the registration, who will have the power to decide how they licensed out or how they transferred to subsequent users of the intellectual property. And a very important, minor but very important point is always in your mutually agreed terms oblige the recipient to say that they got the resources from you when they file an IP application, because that way you attach your country's rights and your status as the provider of the resources and the knowledge into the intellectual property application, and you can actually then use the search function in the international IP system to pick up what happened to your resources to an extent. So this is a way of monitoring compliance that you should, as a matter of course, always include in an agreement around the intellectual property applications. Next slide, please. And then there's the what lawyers sometimes call boilerplate, where you talk about the kind of background nitty-gritty of administering the relationship that you've established in the mutually agreed terms. For example, what are the reporting requirements? How often do you need a progress report on the project? What's the level of detail in that? Who decides whether it is adequate? Is there a process for discussion between the provider and the recipient? The warranties and representations, I mean, either that there aren't any, or that that, for example, you warrant that that there's an exclusivity around it, or so on. This is the sort of stuff where you need to go to the case by case and with proper legal guidance. And very important in any contract which mutually agreed terms is, in the end, it's a contract. You need to spell out what happens when the contract is not honored. All right. So if there's a disagreement about the provisions of the contract, what are the consequences of that disagreement? What are the consequences of breach of contract? If somebody agrees with you that they will do one thing with your resource and then they do something completely different with it, what are the consequences of that? Right, and you need to put that into the contract, but you also need to say how you would get those consequences enforced. And this would deal with things like settlements of disputes, which could be litigation or alternative dispute resolution. What will be the measures for you? How will you get access to justice in the jurisdiction where you choose to exercise, your rights under the contract, etc. Again, very important to get clear legal and professional legal advice on this. And how long is the contract valid for? What are the conditions if the contract's ended by one of the parties? And specifically, if the contract is terminated, which parts of the contract, which provisions of the contract will survive the termination of the contract? All right. For example, if the original contract had prohibited transfer of the resources to third parties, presumably you would want that to also still be the case, even if the contract is then terminated. So that was very briefly, very quickly, an overview of how you can use the guidelines to get stuck into doing ABS. And then the final word from my side is I would very strongly recommend that you don't wait until you have everything that you possibly need sorted out, because you cannot anticipate every eventuality. Nobody can. Nobody knows ABS well enough to be able to say, here's a complete list of everything you need in your toolbox nationally to make it work. So the sooner you get started, and the sooner you get started in a way that provides a portfolio of experiences so that you can build up your national experiences around this. Right. The sooner you are actually going to build also your national capacity to do more and more ABS. So take the toolbox that's already in here, have a look around for your stakeholders and your existing regulations, and then do by all means get started. Because the aim is not to prevent access to the resources. The aim is to ensure that those resources are legally accessed and used in a way that yields benefits for the local communities, for the provider countries, and ultimately for Africa as a whole. Now, that was my presentation. We have asked Letitia Chitwa-Mulomoni from South Africa to just say a few words about how South Africa has used the AU guidelines in revisiting its ABS legislation after the Nagoya Protocol was adopted. So take a liberty here to say, I'm out of here. Letitia, please, you have the floor.
Thank you very much, Pierre, for this opportunity. And good morning, colleagues. My name is Letitia Chitwa-Mulomoni. I'm from the National Department of Environment, Forestry, and Fisheries. And the department is the competent national authority for all ABS-related matters in South Africa. Before I could share our experience in terms of implementing the AU guidelines, I would like to state that South Africa has adopted an approach of learning by doing. And I think we started to implement the ABS process immediately after the bond guideline was adopted under the CBD process. It was way long before the Nagoya Protocol was adopted, but because we have a dedicated program within our government that is looking at the ABS process. We are always behind every new development at an international level, and that's the reason why we were able to also consider the AU guidelines as soon as they were made available, because as soon as the Nagoya Protocol entered into force in 2014, we embarked on a process to now revisit our national legislation just to see areas where we can be able to improve the provisions to make it more relevant to the current circumstances. So now looking at the AU guidelines, I think one thing that we found very useful and interesting for us was the stepwise process for obtaining pick and match. If you look at that document, I think you are going to get a very clear process in terms of how do you go about obtaining the prior informed consent in a stepwise process and moving on to the mutually agreed terms process. I think that is nicely outlined in the AU guideline and is something that is very much useful. And in that process, you'll be able to identify the role of the national focal point or the competent national authority versus the parties to the agreement, like the user and the provider, because normally the competent national authority is not a provider, especially in the South African context. So you will find that you have communities that are coming as the providers, and we will be having like our local industry player or research institution that are also actively engaging with the users from the other side, from the user country. So there's a very clear guidance on how the two come together. In the other important aspect that the AU guideline has really provided to us was creating a distinction between the agreement or the mutually agreed terms that one could consider when engaging with the users. Like starting off with the basic agreement, I think that is clearly outlined, and Pia has even spoken about it. Is quite a very useful guide that is provided there, and also giving us ideas on how do you then progress to a more substantive contract or a complete ABS agreement, as already shared by Pia. So when you look at your national circumstances, you are going to be confronted by a situation that will position you at a basic level of an agreement, moving on to a more concrete or substantive kind of an agreement. So those are some of the important elements that I felt the AU guideline has really helped us with, and also an emphasis on the scope. I think we need to be very, very much clear on the issues of scope, and the AU guideline is very clear on that, because you need to be very clear in terms of the types of or the kind of genetic resource that are covered within your piece of legislation. Like in the case of South Africa, of course, we've adopted a broad term, which is indigenous biological resource. And you can see from the conceptualization of the scope that our focus is more on species that are indigenous to the country. And I think Pia has really put it nicely that the guidelines are designed in a manner that they allow for national discretion and flexibility. So that is where, as a country, you can see element of flexibility coming in. In our case in South Africa, our scope covers plants, animals, and also the microorganisms. So our scope of the biological resource is quite broad, and within that we know that the broad definition of biological resource encompasses the genetic resources as well. And then looking at the permit application form, I think everything that Pia has presented, we found it very useful for us, because that from the permit application form, the application form itself, that is where you extract a lot of information about the project itself or the activities that the user intends to undertake using your genetic resources or associated traditional knowledge. And I think I will stop there. I don't know if there's more that I need to share. I think I'm taking too much time. Thank you.
Well, thanks a lot. Thanks a lot, Pierre, and thanks a lot, Letitia. Pierre, for providing us with this overview. It was a lot, but not comprehensive yet on what the EU guidelines are providing for, but also where the limits are. And also then thanks to Letitia to remind us that it's actually never too late, even if you are in an advanced system, to use them. So it's they suit, let's say, beginners as well as advanced countries in ABS to be picked up and considered. And I would now hand over to Peter again on the role of visualization and translation into legal text. So how can you help us?
Thank you very much. And I think, as you rightfully said, Suel, I think it pretty much fits into what we discussed right now. So we're going a little more, even more into practical questions, still under the overall umbrella of how to get started. Next slide, Eva, please. So visualizations, I mean, and flowcharts in various ways, they're widely used to describe not only ABS systems, all kinds of processes, administrative processes, and but of course also ABS systems and procedures. And on the ABS clearinghouse, for example, there some months ago there has been a new category introduced that is called ABS procedures, because also there we kind of, or the CBD Secretariat also saw the need for really having a precise place where users can go and get the information they need and get a quick overview and quickly grasp what the ABS system in a given country is about. And in this category, ABS procedures in the ABS clearinghouse, there is a specific place foreseen for visualizations. And next slide, please. And we at the initiative we thought about how we could go about this, and trying to get a more practical view on visualizations, we started an attempt to translate actually the EU guidelines into a visualization. And before we go into further details on this, I really want to make sure, and that's why the disclaimer is put here, that this is only a proposed indicative option or a proposed political choice of how to translate the EU guidelines into a visualization. And of course, and we heard that many times, it's up to the discretion of countries to choose all other options. But we thought it might be helpful to try to, actually visualize one option of how to translate the African Union guidelines into an actual text. So next slide, please. So here we go, the ABS procedure, next slide. In the beginning, and we heard it several times, the user most likely should fill in the access demand form. That's because we need this basic information, what is his demand all about. And then he would send it to the CNA. Next slide. The CNA would receive this access demand form and analyze it, analyze the file, and if complete, I mean, if it's not complete, you could go back to the user, ask him to, adjust or adapt or provide additional information. But once it is complete, the CNA would then give instructions as to the next step in the processing of the file, because, of course, there's different options. Next slide, please. For example, if the genetic resource and the intended use fall solely and categorically within the scope of the multilateral system and the purpose of the FAO Treaty on Plant Genetic Resources for Food and Agriculture, then the application shall be transferred to the concerned authority. Because, I mean, you might, when you read the excess demand form, it might come out that this is potentially only covered by the FAO treaty, and then you could send it to the concerned authority. Next, please. If the genetic resources and or the intended use are outside the scope of the Nagoya Protocol as defined in your national way, for example, if it's for customary use, those are examples that are given in the Nagoya Protocol, customary use, exchange of genetic resources between IPLCs or harvesting of resources exclusively for commodity trade or bio trade, there's all these options, then the application could be transferred to the respective authority if the respective access is regulated through other measures. So if there are other measures in your country that cover a certain type of access, as you can identify it from reading the access form, then you could again transfer that access demand to that respective authority, which would be different in every country. Next, please. But if the genetic resource and or associated traditional knowledge and the intended use fall within the scope that you have defined for your country, for the ABS regulatory framework, then the ABS procedure would be triggered. So now we have already pre-selected, is it really ABS or is it maybe covered by some other mechanisms that already exist? Next slide, please. So then, if it's within the ABS procedure, the EU guidelines foresee a simplified ABS procedure and a regular ABS procedure. So if the intended use is covered by one or more of the situations described below, then the simplified ABS procedure, or the notification procedure as it is called in the EU guidelines, is to be followed. And those criteria are, for example, if the access is for non-commercial research purposes, if the access is for research that contributes to conservation and sustainable use, or if it's about current or imminent emergencies that threaten or adversely affect human, animal, or plant health. So those are basically Article 8, A and B. In case there is one of these situations covered, then the EU guidelines propose to go towards a notification procedure. Next slide, please. But if any other form of use is being asked for, then the regular ABS procedure would be triggered. And on the next two slides, we will be going into the details. Next, please. Into the details of the simplified ABS procedure, so the notification procedure. And on the second slide, we will then go into the regular procedure. Next slide, please. So first, the simplified ABS procedure, the notification procedure. How could it look like? Next. CNA, once this decision has been taken that the user has fallen into the notification procedure, the CNA would then communicate this decision regarding the procedure to be followed to the user, and this would be accompanied by the notification form. Because if it's notification procedure, of course, you would have to have a certain way of doing that notification. Next slide, please. And then again, here we have two options. If the national law confers the competence to be the provider for that genetic resource or ATK that is being asked for to an entity or a person other than the CNA, so that might be IPLCs, a parks authority, a museum, botanical garden, whatever it is, a microbial collection, then the user approaches the supplier that is being defined by the national law to obtain PIC, and that in accordance with the relevant procedures. We don't go into any details here. There might be different PIC procedures for different providers, but the essential here is that there might be specific entities or individuals that have the right to be the provider, and so they would be the ones that should give PIC. Next slide, please. And And once the user has obtained PIC, he would then fill in the notification form and would send it together with proof of PIC, so that he has obtained PIC from the provider, would send it to the CNA. Next slide, please. And the CNA would then study the file, and if it's complete, could issue the ABS permit. So that's a very straightforward way. You just fill in the ABS, the access demand form. You get PIC from the provider. You fill in the notification form. There's no negotiation of MUT. There might be some contractual clauses as part of the notification form, which actually makes a lot of sense, to have contractual clauses and conditions for the use in the notification form, but there's no negotiation as such. And then we have that other way that it could go. Eva, next slide, please, because it's also possible that the CNA is the provider. In some countries, that is the case. Or for specific resources, that could be the case. If that's the case, then the CNA gives the PIC according to a procedure that would need to be decided upon. Next slide. So that makes it here even a little easier, because then the user fills in the notification form and sends it to the CNA. The CNA is the one who gave the PIC, so no need for proof of PIC. And then next slide, based on this notification form, the CNA could then again issue an ABS permit. So this is a very simple notification procedure. Next slide, please. Now we would go into the regular ABS procedure, which is slightly more complicated, but it's also manageable. Next slide. Again, the CNA would communicate the decision regarding the procedure to be followed, in this case, the regular ABS procedure, to the user. But in this case, the CNA would attach a basic ABS agreement to this information of the user, which procedure needs to be followed. The basic ABS agreement is one of the annexes that Pierre presented during his presentation, one of the annexes of the AU guidelines. Next slide, please. Here again, we have two ways that the procedure could go, and it's the same thing. So if the national law confers the competence to be the provider to an entity or a person other than the CNA, this entity or person would be the one to give the PIC. Next slide. And this is the difference to the notification procedure. Now, once the PIC has been obtained, the user would need to negotiate and sign, based on the basic ABS agreement, MUT with the relevant provider. Next slide. And the user would then again put together a full dossier, which would comprise the access demand form, the proof of PIC, and the signed MUT, and would then send the full dossier to the CNA. And once again, the CNA, next slide, would examine the dossier, and if it's complete, would then issue the ABS permit. And then on the other hand, next slide, it's the same thing, just with the difference that the CNA in this case would be the provider. So that would be the CNA then who gives the PIC. Next slide. The negotiator would, the user would then negotiate and sign the MUT with the provider, which in this case would be the CNA. Next slide. Again, the user would put together a full dossier and send the full dossier to the CNA, based on which, next slide, the CNA can then emit the ABS permit. So this is a very broad way of visualizing, or a very general option to visualize the AU guidelines, but we thought this might put a little more flesh on the bones and might things a little easier to understand. Next slide. So the question is also, when would one work on such a visualization? And we thought about that and would like to make a proposal. I mean, we started today's session with a multi-stakeholder process, and one could then work with a core group on a first proposal of a visualization. Actually start as one of the earliest things. I mean, we talked about stakeholder map and legal gap analysis, of course, but also start working on a visualization. And then present that draft visual, like just to describe how you and your core group foresees the ABS system to work in your country. And then present that draft visualization to the decision-making mechanism that has been set up for ABS, whatever it is. We discussed that briefly in the multi-stakeholder part. And within this decision-making mechanism and based on that visualization, you can then create a consensus, adapt and validate the visualization. And we learned that it really, I mean, if you work on a legal text without having a visualization already in mind, very different interpretations of the legal language can come up. And it might be a good idea to somehow, reverse the order of doing it. So, because such a visualization would then help to channel these theoretical discussions on an ABS system into a common understanding, because a visualization is a lot easier to understand. Next slide, please. And then there's that, like, once you would have this visualization and you have this common understanding of the most important stakeholders, this would actually be a great help for the legal experts to translate this visualization into legal text. So when you elaborate terms of reference for a national legal expert to draft those texts, you could simply include the visualization as one key element in those terms. Because you could basically ask the legal expert to translate this common vision into a legal text. So the visualization will provide that guidance to the legal expert, and who would then translate it. Next slide, please. So to wrap it up, and I went through it very quickly, but I think we're then almost back on time. To get started, we propose to use the AU guidelines for orientation and for practical guidance and practical and strategic guidance, as Pierre pointed out. Use a visualization to create a consensus on how the ABS system of your country should be set up. Then use this visualization to guide the legal experts in drafting the text. And one might as well think about including the visualization as an annex to the legal text that will be then developed. And with that, I'm finished, and I think we're going into another round of questions. Thank you very much.
Yes, Peter, absolutely. And thanks for this presentation and daring to put some text, legal text of the African Union guidelines or semi-legal text into something more tangible, which I'm sure will trigger a bit of discussion. I know that you have made some experiences now in supporting countries with this visualization approach, particularly French-speaking countries, and that it was highly appreciated. I myself also work with the visualization approach, also with countries that already have a legal framework, but maybe then rather at the level of on spelling out the implementation regulations, for example, so at the level of decrees and so on. So how would things, mechanics work in practice? Right, so if we could go now then to the next slide and look into what will follow. So we are more than happy to react on questions that you did not pose to us today, because maybe some are still evolving in your mind. So please send us emails with questions that may then also be some inspiration for topics of the next webinars, or how we may integrate it in there. Well, now referring to the next steps, after we had the general introduction and a bit on how to get started with some feedback also from practical cases like from South Africa, from Lactitia, we will go a little bit more into the legal arena on the 28th of May with the choice of legal instruments, what is suitable at what level, what is recommended, what are experiences. So this will be a bit more advanced than our discussions than we had today, but I think quite important because this also has to do with processes, with timing, with financial matters, and then more on real technical implementation related issues on the 11th of June. But there we will provide a little bit of an outlook at the end of the next webinar, what the issues will be in the fourth webinar. We will share, of course, the report of this meeting, and please, once again, you can put your email in the chat function if you haven't done so. And we will, as it's already now usual practice, send out the invitations for the next webinar. Well, this brings me basically to the closer of this webinar. I have asked now two people to say some closing words before Hartmut will finally close the meeting. I would like to invite now Marlet from the African Union Commission maybe to share some thoughts of on this webinar and the webinars as such before we then close the meeting finally. So Marlet, please, it's with you. I hope that the connection will be strong enough.
Thank you so much, Suhail, and greetings to all colleagues. Once again, this webinar, I take it, has been concluded very successfully. Very interesting questions on this practical application of the AU guidelines. I think I would like to thank Pierre once again for really going into the details so eloquently, and also Letitia for bringing it home to us on how this guidelines are a hands-on tool for the implementers, the national ABS focal points. Marceline also for making a call to everyone to really consider the guidelines, to use them, in that they are very practical, they're very elaborate, and they really do touch on a lot of issues. Benefits, regarding benefits, the guidelines are very clear and they articulate possible benefits for biodiversity, including potential threats to biodiversity, which, of course, has a transboundary angle to it, transboundary implications to it. And this needs the states, neighboring countries in a region, also touches upon mandates of the regional economic communities to which most of your countries are members to. The RECs, as you all know, are very active in conservation issues, on biodiversity issues, and some also have been interested and engaged on issues of ABS as well. And the guidelines also take into account what role regional economic communities or regional blocs could play in the coordinated implementation of the Nagoya Protocol, which is perfectly in line with what the provisions of the Nagoya Protocol and the CBD also outline with regards to regional collaboration to implement the third objective of the CBD, as you all know. Having said that, Suhail, I would probably like to call on the member states to reiterate what Marceline was also saying on his text, to consider and review the AU guidelines, both the strategic document as well as the hands-on tool, the policy document and the strategic document, which are very, very useful and very elaborate in their practical nature. Now, we all had been preparing for 2020, which is a very important year for all of us because of all the technical meetings that are happening in the interim. before the COP15. But unfortunately, we've been met with this pandemic, which is why I would really like to thank our partners, the ABS Capacity Development Initiative, for really working hard to ensure that our momentum is intact in spite of this extraordinary circumstances that we are faced with, and that we do keep engaged, and that we do keep about ABS, talking about the Nagoya Protocol and national implementation, as well as international obligations that we will have to answer to when come COP15. So I would call on all of us to stay engaged, call on all of us to also, especially those negotiators here, to stay engaged with the rest of the group with regards to strategizing and really having the conversations on how we strengthen our position as a regional bloc, and how we take into account all of these different elements that we are really getting sensitized on. And having said that, I would like to thank everyone for their participation. And Suhail, thank you for the opportunity for having this closing remarks. And I will hand it over to you. Thank you.
Thank you, Marlet. Without further ado, to Hartmut to really close the meeting. And well, from my end, stay well, stay healthy. Hartmut.
Yes, thanks, Zul. I've been following this meeting quietly and listening to all the presentation and saw them. And I think that also taking into account that we are learning with these kind of online meetings, and we need to learn how to use this time and opportunity best. I think that was a good step to bring in Letitia, for example, to really report about national experiences and not only just giving presentations. So, and also see that Kavaka was referring to getting more experiences from the other people. So I think that should be a good reminder for us to continue to develop this format, to bring in the experiences of the others, so to enable us to come into a dialogue and a real exchange. So that's, I think, we will consider and present in next meetings. I like to thank everybody who participated, and it was quite a number. And I also like to thank the team who is very, very busy to prepare all these meetings and to conduct them. I think it went really smooth, and I look forward to see you again in the next opportunity. So, and we wish you a good day.